The Supreme Court sets the date for a major abortion case that could challenge Roe v. Wade. The High Court announces oral arguments for Dobbs versus Jackson's Women's Health Organization will be held December 1st. Dobbs centers around a Mississippi pro-life law that bans most elective abortions after 15 weeks. The justices will consider whether pre-viability abortion bans are unconstitutional. In her brief to the court, Mississippi Attorney General Lynn Fitch asked the Supreme Court to overturn previous landmark rulings on abortion, Roe v. Wade and Planned Parenthood v. Casey, arguing those decisions shackle states to a view of facts that are decades out of date. Fitch wrote, quote, "Under the Constitution, may a state prohibit elective abortions before viability? Yes. Why? Because nothing in constitutional text, structure, history, or tradition supports a right to abortion." Joining us now is Mississippi Attorney General Lynn Fitch. Welcome to the show. It's so good to meet you.
Thank you. It's an honor to be with you today.
It's great to be with you. So December 1st, the Supreme Court is taking up Mississippi's pro-life law and will consider whether pre-viability abortion bans are unconstitutional. Can you break down for us what is your argument in defense of Mississippi's pro-life law?
Well, we were delighted today to get the date for December the 1st, and we're all moving forward to that date. And this has been such a vision and a strategy that we've all put together with our friends and our partners to get to this point. It's extremely exciting. Mm-hmm. It is truly a chosen case by God, and we get the opportunity to make this argument on why Roe v. Wade and Casey v. Planned Parenthood are not substantial cases, and it should be overturned, and that there's no constitutional right. So we saw our brief as the motion to set into place to have that real honest conversation about those cases and why they should be overturned. And so an exciting opportunity to really share across the vision of what so many of us believe in. We believe in the sanctity of life, the dignity of all, and this is truly a remarkable platform through our Dobbs case to bring it to the United States Supreme Court.
It is a historic moment. So what is your response when people say Mississippi's abortion law, that is unconstitutional?
Well, they're inherently wrong because our situation is, it's been percolating along, and it is. It's all about the protection, again, of the babies, the mothers, the integrity of the medical profession, and we have to look at it from a holistic viewpoint. We can't just look at slivers. We have to look at the entirety of this case and the magnitude. So in doing that, we have to talk about those precious babies, unborn and the ones to be born, the mothers, and again, how did the medical profession support them? And so we have to look at from that integrity aspect. So as we move forward, that's certainly what we'll be doing, and it is an opportunity for the state's interests, the state's rights to be brought up, because the bottom line is this is a rule of law. This is a rule of law case, needs to be returned to the states. States protect. They are the ones that have the legislators, the governors that we all elect. And their job is to act upon the will of the people, to act upon what's in the best interest of people across the state, and that's what they do. And if they aren't doing that, then they have to be held accountable, and certainly people can go to the ballot box and change that.
You mentioned the brief that you submitted, and you directly asked the court to reconsider Roe v. Wade with Dobbs. Tell us more about that and why you think this might be the case to do that.
Well, it absolutely is the case to do that. I mean, again, this case had been percolating for a number of months. Again, we were thrilled that our case was selected, and ours is very distinguishable. I mean, truly, we have to have the conversation. We need to have the real clear dialogue about why it doesn't fit. Things have changed, you know, in nearly 50 years, and you have to think about 50 years. We've had this very blurred line when it came to viability. So every court had a different opinion, and you could never really come and rectify this court against that one, and certainly Roe never gave clear direction. So you have this special set of rules now that apply to abortion based on all these different precedent cases. And so which one works? How do you know which one you follow? And so that's why we said it is absolutely time to overturn Roe v. Wade and give clear and distinct clarification on abortion and return it back to the states.
A lot of eyes are on this case. Considering the Supreme Court recently upheld Texas's heartbeat law, does that give you hope that they might rule in your favor on this case?
Well, absolutely. And certainly very different situations, different cases, different set of facts and everything. But it does. It gives us great hope that our court, our justices are prepared, and I truly think they are. I think the makeup of the court, the timing is right, and again, we've gone for so long, and there's so much conflict going on the court, and I think they're looking for an opportunity to really give that clarification for all of us moving forward. And when they do that, think about this. The lives that will be touched, the babies that will be saved, the mothers who get a chance to really redirect their lives, and they have all these new and different opportunities that they didn't have 50 years ago.
Pro-abortion attorneys filed their brief with the Supreme Court a few days ago, and they say if the Supreme Court rules against them, it will pave the way for women to do dangerous abortions themselves. What's your response when you hear claims like that?
Well, I'll tell you, their brief was very unfounded. It really didn't say anything except a lot of chaos. It didn't really give any, oh, we should do this, or here's why Roe should stay intact, or why Casey should stay. None of that. It really said, oh, there's going to be a tangled mess here, and we really have to avoid overturning Roe. But here's the difference. They offered no distinction. They offered no platform, any positive direction for the women. Wasn't empowering to the women. They weren't supportive of the children. And that in itself shows that they really weren't completely understanding and knowing what the next step should be for these babies, for these women. And so now it's very different. Like I said, 50 years ago, for professional women, they wanted you to make a choice. Now you don't have to. Now you have the opportunity to be whatever you want to be. You have the option in life to really achieve your dreams, your goals, and you can have those beautiful children as well.
Yeah, absolutely. We love them both. We love both the mothers and the babies. Do you see this abortion case, Dobbs versus Jackson Women's Health, as the most prominent and significant abortion case since Roe v. Wade? How do you place this in your mind?
Absolutely. This will be the most significant, game-changing case probably in my lifetime that affects Roe, overturning the Roe v. Wade and sets us on a new course. And just think about the uplifting, the changing of direction for, again, these new babies we bring in, these women, and everyone knows it's all right. It's acceptable. You can have these beautiful children and you can have your careers. And so that really gets us into how do we empower women? How do we prepare for that next step? And we have to look at this whole vision and strategy. And I just, think God has given us this opportunity to be here.
So you really do see God in this.
Yes, and the prayers, the uplifting, it's just been incredible for myself, for the team. We know that we've been lifted up. We know that people have been there for us, helping us every step away from everything that was been written, every messaging that we're talking about, because I truly believe, as does my team, there's this huge groundswell of people who are excited about the answer to this case, who've been looking for the opportunity to talk about and have true, clear dialogue about abortion and why that's not a constitutional right.
Yeah. On a personal note, I just have to ask, how does it feel that it is your state's pro-life law that is up at the Supreme Court taking on this important question?
Well, it's very humbling, very humbling. And again, I feel like we were selected for all the right reasons, to really frame it on the viability question. And again, if you really look back over 50 years, gosh, the women have changed, men have changed, the career paths have changed, and certainly we know advances in medicine have changed. And so to finally be able to take a hard look at this, again, it's an honor and it's very humbling for our state.
Well, we now know those oral arguments are December 1st, just over 2 months out. What does that preparation look like ahead of then?
It's going to be a lot. We've been waiting for this day. We've had a whole strategy put together from the very beginning. And when it came to fruition, we had a plan. We've been working our plan. We knew exactly who we needed to be talking with and the messaging and then writing the brief. And I have to say, we really wanted to take that brief and we wanted to leave no stone unturned. We wanted to hit it hard. We wanted to be very real. We wanted to talk about here are the issues and how do we overcome. And you couldn't do it by just looking at pieces and parts. Right. You had to talk about the children, the mothers, the medical community. You had to talk about the safety, the health, and preserving life.
Well, be assured of our prayers for you ahead of December 1st and ahead of those oral arguments. Mississippi Attorney General Lynn Fitch, thank you so much for your time.
Thank you. Thank you for having me.